One of the jurors from the Michael Brown grand jury now suing St. Louis County prosecuting attorney Bob McCullough. The unnamed juror wants to speak out on what happened in the Darren Wilson case, but grand jurors are prohibited by law from discussing cases they were involved in. The American Civil Liberties Union of Missouri is representing Juror Doe. The lawsuit names McCullough as a defendant since he'd be the one to bring charges against the plaintiff. ACLU claiming the lifetime gag order against grand jurors is unjust. Matt Fleischman is a personal injury attorney here in Charlotte, here to discuss the legal aspects surrounding this lawsuit from the juror. Now, they're saying the gag order is unjust, but it's not uncommon.
No, I mean, when you serve on a grand jury, you have a lifetime gag order, and if you talk and discuss what's discussed at the grand jury, you're criminal contempt and you can go to jail.
So under what circumstances would they reverse this and let the jurors speak?
You have to have a compelling interest. It's actually an interesting case where you've got, on the one hand, the gag order, which society has determined is necessary to have grand juries. You want witnesses to show up and feel like they'll be protected. You want the grand jurors to feel like they can be protected. If there's a criminal investigation that's ongoing, you don't want the potential defendant to know that there's a grand jury going on. So you have on that end that compelling interest. And on the other end, you have this grand juror who has a First Amendment right to discuss what happened, and so the court's going to determine, which one's going to outweigh the other.
So what do you think in this case? Do you think this is something they're going to reverse and let the jurors talk?
I think in this case, because you have so much news on this event, you've had the district attorney take the unusual steps of already disseminating all the information in the grand jury. Everybody in the country has been talking about this except for those 12 people. I think it's certainly possible. It's certainly not a frivolous lawsuit, I can tell you that.
Okay, well, we'll see about that, of course. And the other big thing, I was reading articles about that this morning, NAACP rather, now saying that they're calling for a brand new grand jury as a whole. Mm-hmm. What's the precedent there?
That's going to be up to the district attorney to see whether they want to bring that. I think that's going to be unlikely.
Okay.
Now, the district attorney can always bring charges on his own, but I think he's made his position quite clear that charges in this case will not be brought.
Mm-hmm. All right, Matt Fleischman, thank you so much for weighing in. We'll keep you posted, of course,
my pleasure.
as this progresses. Eric.
All right, nearly one.